evidence only for that purpose and for no other. You have heard evidence of a statement that a witness made before the trial. If you decide that the witness made that statement, you may use that statement in two ways. One, to evaluate whether the witness's testimony in the courtroom is believable. And two, as evidence that the information in that earlier statement is true. Witnesses were allowed to testify as experts and to give opinions. You must consider the opinions, but you are not required to accept any opinion as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the testimony of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and to give an opinion based on the assumed facts. It is up to you to decide whether an assumed fact has been proved. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. If the expert witnesses disagreed with one another, you should weigh each opinion against the other. You should examine the reasons given for each opinion and the facts or other matters on which each witness relied. You also may compare the expert's qualifications. Witnesses who were not testifying as experts gave their opinion during the trial. You may, but are not required to accept any such opinion as true or correct. You may give any opinion whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. You have heard character testimony that the defendant is an attentive, informative, careful, cautious, compassionate, loyal, and knowledgeable physician, and has a good reputation for financial generosity and selflessness in the communities where he lives or works. You may take that testimony into consideration, along with all the other evidence, in deciding whether the people have proved that the defendant is guilty beyond a reasonable doubt. Evidence of the defendant's good character for these traits and his good reputation for these traits by itself can create a reasonable doubt. However, evidence of the defendant's good character may be countered by evidence of his bad character for the same trait. You must decide the meaning and importance of the character evidence. Counsel for the people was allowed to ask a character witness for the defendant if that witness had heard that the defendant had engaged in certain conduct. These "have you heard" questions and their answers are not evidence that the defendant engaged in any such conduct. You may consider these questions and answers only to evaluate the meaning and importance of a character witness's testimony. A defendant has an absolute constitutional right not to testify. He or she may rely on the state of the evidence, and the defense may argue that the people have failed to prove the charge beyond a reasonable doubt. Do not consider, for any reason at all, the fact that the defendant did not testify. Do not discuss that fact during your deliberations. Do not consider such a fact or let it influence your decision in any way. You have heard evidence that the defendant made oral statements before the trial, you must decide whether the defendant made any of these statements, in whole or in part. If you decide that the defendant made any such statement, consider the statement, along with all the other evidence, in reaching your verdict. It is up to you to decide how much importance to give to any such statement. You should consider with caution any statement made by the defendant tending to show his guilt, unless that statement was tape recorded. The defendant may not be convicted of any crime based solely on his out-of-court statements. You only may rely on the defendant's out-of-court statements to convict him if you conclude that other evidence shows that the charged crime was committed. That other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. The identity of the person who committed the crime may be proved solely by the defendant's statements. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. If you find that the defendant made a false or misleading statement before this trial relating to the charged crime, knowing the statement was false or intending to mislead, that conduct may show he was aware of his guilt of the crime, and you may consider it in determining his guilt. If you conclude that the defendant made the statement, it is up to you to decide its meaning and importance. However, evidence that the defendant made such a statement by itself cannot prove guilt. If you conclude that the defendant tried to hide evidence or concealed evidence, that conduct may show that he was aware of his guilt. If you conclude that the defendant engaged in such conduct, it is up to you to decide its meaning and importance. However, evidence of such conduct by itself cannot prove guilt. The people are not required to prove that the defendant had a motive to commit the charged crime. However, in reaching your verdict, you may consider whether the defendant had a motive. Having a motive may be a factor tending to show that the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. Charged crime, involuntary manslaughter. The defendant is charged in count 1 with the crime of involuntary manslaughter in violation of Penal Code Section 192, Subdivision B. The people are alleging that the defendant committed that crime based upon two theories. 1, that the defendant committed a lawful act with criminal negligence. And 2, that the defendant failed to perform a legal duty with criminal negligence. In the following instructions, I shall define the crime of involuntary manslaughter based upon each alleged theory. The defendant is charged in count 1 with involuntary manslaughter in violation of Penal Code Section 192, Subdivision B, based upon the theory of the commission of a lawful act with criminal negligence. To prove that the defendant is guilty of this crime based upon this particular theory, the people must prove that, 1, the defendant committed a lawful act but acted with criminal negligence, and 2, the defendant's act caused the death of the alleged victim, Michael Joseph Jackson. The people allege that the defendant committed the following lawful act with criminal negligence. The defendant, as a licensed physician, administered propofol. Criminal negligence involves more than ordinary carelessness, inattention, or mistake in judgment. A person acts with criminal negligence when, 1, he or she acts in a reckless way that creates a high risk of death or great bodily injury. And 2, a reasonable person would have known that acting in that way would create such a risk. In other words, a person acts with criminal negligence when the way he or she acts is so different from the way an ordinarily careful person would act in the same